आज हम लोग सेपरेशन ऑफ पावर्स के बारे में बात करेंगे। सेपरेशन ऑफ पावर्स एडमिनिस्ट्रेटिव लॉ में बहुत ही एक इम्पॉर्टेंट टॉपिक है। बिफोर वी गो ऑन डिस्कसिंग एनीथिंग अबाउट सेपरेशन ऑफ पावर्स, सबसे पहले हम लोग देखेंगे व्हाट इज द मीनिंग ऑफ सेपरेशन ऑफ पावर्स। In a system, government has three important functions to discharge, that is legislative, executive and judicial. And for discharging all the three functions, government has three specific organs, that is legislature, executive and judiciary. The meaning or the concept of separation of powers, it requires that all the three organs, that is legislature, executive and judiciary, should be kept separate from each other. Normally, there will be no encroachment on the field assigned to one by the other. Normally, legislature cannot exercise judicial or executive functions. Similarly, executive cannot exercise legislative or judicial functions, and normally, judiciary cannot exercise legislative or executive functions. Now, if we have a look at the origin of separation of powers, then it dates back to the great Greek philosophers Plato and Aristotle. They for the first time talked about separation of powers. Then it was developed by Godin and Locke. But unfortunately, they could not systematically lay down the principles or the foundation of separation of powers. Credit goes to Montesquieu, who in his classic work, The Spirit de Loi, published in the year 1748, talked about separation of powers. Montesquieu said that if legislative and executive powers are united in the same person, then there can be no liberty. There will be an end to liberty if these two functions, legislative and executive functions, are vested or united in the same body or person. Now, the concept of separation of powers in the Constitution of USA. The US Constitution was adopted in the year 1787, and in the Constitution of USA there are three specific articles which provide for the separation of powers in USA. Article 1, Article 2 and Article 3. Article 1 specifically says that the legislative powers of USA shall be vested in the US Congress, consisting of two houses, that is House of Representatives and the Senate. Article 2 says that the executive powers of the USA shall be vested in the US President, and Article 3 says that the judicial powers shall be vested in the US Supreme Court and other subordinate courts in USA. So, we can very rightly say that the separation of powers, the concept of separation of powers, has been very beautifully applied in the US Constitution. Now, coming to India, the position in India. First of all, in Indian Constitution, no such express provisions. We unfortunately do not have three articles which specifically provide for the separation of powers in our country. Except Article 50, we have only Article 50. Article 50 says that judiciary should be kept separate from the influence of other two organs, that is legislature and executive. In India, what we actually experience, that there is functional overlapping. Why I am saying functional overlapping? Because very interestingly, Article 52 of our Indian Constitution. Article 52 says that there shall be a President of India. Article 53 says that the executive powers of the Union shall be vested in the President, and which shall be exercised by him either directly or through the officers subordinate to him in accordance with the Constitution. So Article 52 and Article 53, these two articles are making President of India the chief executive head of the Union. Now interestingly, Article 79, which speaks of composition of the Parliament. It says that the Parliament of India shall consist of three things: Rajya Sabha being the upper house, Lok Sabha being the lower house and the President of India. Why I said functional overlapping? Because of this. Because by virtue of Article 52 and Article 53, President of India is the chief executive head of the Union, and similarly at the same time he is also an integral part of the Parliament, which is the central legislative body. So there is functional overlapping. The chief executive head of the Union is an integral part of the central legislative body. That is why I said that in India there is functional overlapping. Now, moving on to the next point, that is separation of powers as basic feature. In a number of cases, separation of powers was held to be part of the basic structure. Starting with Keshavan Bharti versus State of Kerala, 1973 SC 1461, followed by so many other cases like Indira Nehru Gandhi versus Raj Narayan, and 1975 SC 2299. Then ADM Jabalpur versus Shivkant Shukla, decided in the year 1976, and recently Supreme Court Advocates on Record Association versus Union of India, 2016, 5 SCC 1. There was a constitution bench consisting of 5 Supreme Court judges. By 4:1 majority, the NJSC Act was held to be unconstitutional because, in the opinion of the Supreme Court, there was an interference in the appointment process of the judges. So, Supreme Court once again recently in 2016 said that interference in the appointment process of judges is a violation of separation of powers, which is a basic feature of our constitution. So, up to this for now. Thank you.